Hello and welcome to the Employment Law Centre of Western Australia. In this video we will talk about employment law in Western Australia and some of the common issues that come up when you apply for a job and while you're working. We have a separate video on our website which covers some of the things you can do if you lose your job. Employment law can be complex and difficult to understand. On top of that, the laws often change, so please remember that the information in this video is a general guide only. It is not legal advice and the information is for Western Australian employees. If you want legal advice about your specific employment law issue, please call our telephone advice line or contact a lawyer. All employees have workplace rights. It is important to know what your rights are so that you can do something about them if you have a problem. There are two parts to this video. In the first part, we'll look at 3 important things which every employee in Western Australia should know about where employment laws come from and how they can apply to you. In the second part, we'll look at some common questions about employment law that might come up when you are applying for a job and when you are working, such as joining a union, making sure you're paid correctly, discrimination, bullying and sexual harassment. We'll also talk about some general protections which the law provides. There are 3 important things which every employee in Western Australia should know. Firstly, you are either a national system employee or a state system employee. Secondly, you are either a casual or a permanent employee. And thirdly, the laws that apply to you as an employee come from a number of sources, and these can be different for each employee. So even if 2 people work for the same employer and are doing the same job, their employment rights could be different. Let's look at each of these in more detail. Employees in Western Australia are either national system employees or state system employees. The system you fall into will depend on the structure and business activities of your employer. In general, you are probably a national system employee if your employer is a proprietary limited business or is incorporated in some way and has substantial trading or financial activities. In general, you are probably a state employee if your employer is a sole trader or partnership. Please be aware that there are exceptions to these general rules. For more information on how to decide whether you're a national system or state system employee, you can read the fact sheet on our website called National System Employee or State System Employee. Which one are you? If you are still not sure, you can call WageLine, which is the state government's free information service, and someone can help you work out which system you are in. It is important to know whether you are a casual or permanent employee, as this will affect your entitlements and workplace rights. Casual employees do not have guaranteed hours, do not have regular start and finish times, do not get annual leave, do not get paid sick leave, and do not have an expectation of ongoing work. Casual employees are paid additional money known as a loading to compensate them for not having these things. A casual loading is normally 20 to 25% extra. On the other hand, permanent employees have regular working hours, are entitled to paid annual leave, are entitled to paid sick leave, have an expectation of ongoing employment, and are usually entitled to at least 1 week's notice if dismissed. It is important to remember that legally you can be considered a permanent employee even if your employer has told you that you're a casual employee. For more information on the differences between casual and permanent employees, you can read the fact sheet on our website called Permanent or Casual Employee. Which one are you? Your employment rights, which set out your entitlements and conditions of employment, come from a number of different sources. You should make sure you know where your own employment rights come from and what they are, because they can make a big difference to what you can do if you have a problem. There are 3 main sources of employment rights. These are laws, which set out your minimum conditions of employment, awards and industrial agreements, and contracts of employment, whether written or verbal. All employees have rights under the law which set out minimum conditions, and all employees have a contract of employment. Most, but not all employees, are covered by an industrial award or agreement. Minimum conditions under the law are basic rights that apply no matter what. They form a safety net of employment rights. An employer cannot refuse to give them to you, and you cannot bargain them away. If you're a national system employee, these are called the National Employment Standards and are found in the Fair Work Act. If you're a state system employee, these are found in a number of laws, including the Minimum Conditions of Employment Act. There are some minimum conditions which all permanent full-time employees are entitled to, regardless of whether they are national or state employees. These are the minimum wage, 4 weeks paid annual leave, 2 weeks paid personal leave, a working week of 38 hours plus reasonable additional hours, paid public holidays, paid leave for jury duty, notice if you're going to lose your job, and long service leave. Many permanent employees are also entitled to parental leave in the event of a birth or adoption, and redundancy pay in the event of a redundancy. However, there are some eligibility requirements for these entitlements. For more information on minimum conditions, you can read the fact sheet on our website called Minimum Conditions at Work. The second source of employment rights are awards and industrial agreements. The minimum conditions of employment under the law that we just discussed apply to employees in all types of industries and jobs. On the other hand, awards and industrial agreements contain rules that just apply to particular industries, occupations, or workplaces. Awards and industrial agreements cover issues like job classifications, pay rates, overtime rates and other penalty rates, pay loadings including casual loadings, and procedures to follow if there is a dispute about your employment. The main difference between awards and industrial agreements is that on the one hand, awards usually apply to a general industry or occupation, such as the Cleaning Services Award or the Hair and Beauty Industry Award. On the other hand, industrial agreements usually apply to a single workplace or enterprise. This is why they are sometimes called enterprise agreements or enterprise bargaining agreements. Normally, employers and employees cannot choose whether or not they are bound by an award. If an award applies to an industry, the employers and employees in that industry are required by law to follow the award. However, if an employer and a group of employees agree to a different set of rules, they may be able to register these different rules as an industrial agreement. Once registered, the industrial agreement replaces most or all of the rules in the award. The most important thing to remember about industrial agreements is that they must put the employees in an equal or better situation than they would have been under the award that is being replaced. To find out whether you are covered by an industrial award or agreement, you can call the Fair Work Info line if you're a national system employee on 131394, or Wage Line if you're a state system employee on 1300 655 266. The third main source of your employment rights is your contract of employment. Every employee has a contract of employment, even if nothing has been written down or signed. Employment contracts can be written down on a piece of paper or in an email. They can also be agreed to in person verbally. Usually your employment contract will be in one document. However, it can be made up of a combination of things which have been written down in a letter or email, as well as things which have been agreed to in person. Of course, verbal contracts can be much more difficult to prove. So if you have been promised something important, it's usually best to get it in writing. Generally, your contract of employment cannot give you an entitlement that is less generous than the laws that set out your minimum entitlements of employment, or an award or industrial agreement that applies to you. However, there are some exceptions to this rule. If you think that your contract is less generous than a law, award, or agreement that applies to you, you may wish to seek legal advice. You should also know that if there is a problem with your contract, you have 6 years from the date of the problem to file a claim. Now we're going to look at some common employment law questions people have when applying for a job and while working. The first question is about unions. When you are offered a job, you may be asked if you would like to join the union. A union is an organised group of workers who come together to represent, advocate, and make decisions about improving the conditions of their workplace. They also provide direct assistance to members experiencing problems at work. If you agree to join the union, you will probably have to pay union fees. It is entirely your choice whether or not you decide to join a union. You should not be pressured into joining a union, and you should not be pressured against joining a union. If either of these things happen, you may wish to seek legal advice. Another common question is how to know whether you are being paid correctly. In general, employees are entitled to be paid at least the minimum wage. You may be entitled to a higher wage though if your employer agreed to pay you a higher wage, or you're entitled to a higher wage under an award or industrial agreement that applies to you. There are some exceptions to the standard minimum wage. For example, there are special minimum wages for employees who are under the age of 21 or who are an apprentice or trainee. Employees with a disability may also be paid an assessed wage, which is less than the usual adult minimum wage. Remember that when we talk about your entitlement to be paid correctly, we're not just talking about your wage. We're also talking about your annual leave, personal leave, long service leave, and other monetary entitlements which your employer may owe you. If you aren't sure about whether you're being paid correctly, you can call the Fair Work Info line if you're a national system employee on 131394, or Wage Line if you're a state system employee on 1300 655 266. If you aren't being paid correctly, you have 6 years from the date of the underpayment to make a claim for the outstanding amount. You can make this type of claim even if you aren't still working for the same employer. Another common question is what to do about discrimination or sexual harassment in the workplace. The law protects you against discrimination and sexual harassment when you are applying for a job and when you are working. Discrimination is when a person is treated less favourably because of a certain characteristic. In Australia, it is unlawful to discriminate against a person on the basis of their age, race, sex, family or carers' responsibilities, physical, intellectual or mental impairment, marital or family status, political or religious convictions, pregnancy, sexual orientation, and a number of other characteristics. Discrimination does not have to be deliberate. If a rule or practice has the effect of discriminating against a person, then it might be against the law even if the discrimination was not intended. Sexual harassment is unwelcome conduct of a sexual nature. It includes an unwelcome sexual advance or request for sexual favours. Sexual harassment does not have to be repeated or continuous behaviour to be against the law. A single instance of sexual harassment might be in breach of the law and allow you to make a claim. For more information on discrimination and sexual harassment, you can read the fact sheet on our website called Discrimination and Sexual Harassment, or you can look at the fact sheets on the Equal Opportunity Commission's website at www.eoc.wa.gov.au. You can also telephone them on 9216 3900. If you have experienced discrimination or sexual harassment, you may be able to file a claim with the Equal Opportunity Commission. Remember that you have 1 year from the date of the discrimination or harassment to make your claim. Bullying is repeated, unwanted, and unreasonable behaviour that creates a risk to health and safety. Examples of bullying can include verbal abuse, excluding or isolating a colleague, intimidating or humiliating a worker, or giving someone meaningless tasks to perform. Bullying at work can be a very stressful experience, and it is helpful to know what options are available to you if you're experiencing bullying. Depending on the particular circumstances, there are a number of things you can do. If you're a national system employee, you can make an application to the Fair Work Commission for an order to stop the bullying. The Commission can make a number of different types of orders, although it cannot award you compensation. If you believe the bullying is a risk to your mental or physical health, you can report the behaviour to WorkSafe on 1300 307 877. If you experience bullying which has racial or sexual harassment overtones or is discriminatory in nature, you can call the Equal Opportunity Commission on 9216 3900. You could also see if there is an internal procedure for dealing with bullying in your workplace. Some workplaces have a contact officer who is responsible for looking into bullying issues. The information about this may be in your industrial award or agreement, contract of employment, or workplace policies and procedures manual. For more information on bullying, you can also read the fact sheet on our website called Workplace Bullying. If you're experiencing bullying in your workplace and you're still not sure about how to deal with it, you may wish to call our advice line or contact a private lawyer. In some situations, the law provides employees with general protections if their employer has taken an adverse action against them. Only national system employees have these general protections. If you're applying for a job where you would become a national system employee, you may also be protected. Basically, you have to be able to show two things. Firstly, that you have a right which is protected by the law, and secondly, that the employer took adverse action against you because of that right. Examples of adverse action which an employer might take include discriminating between you and other employees, altering your position to your prejudice, taking disciplinary action against you, or demoting or suspending you. Adverse action can also be threatening to do any of these things. Some examples of rights which the law protects include making a complaint or inquiry in relation to your employment, participating in a process which you have because of a workplace law or workplace instrument, having a role or responsibility under a workplace law or workplace instrument. The law also protects you from having adverse action taken against you because of things like your race, colour, sex, sexual preference, age, physical or mental disability, marital status, family or carers' responsibilities, religion, political opinion, or social origin. This may seem like a lot of rights which are protected, but there are much more which we haven't mentioned. Having said that, you should also keep in mind that you may not be protected if the inherent requirements of your job mean that the adverse action was necessary. If you think that your employer has taken adverse action against your rights, you may wish to seek legal advice. For more information, you can read the fact sheet on our website called General Protections for National System Employees. You can also call the Fair Work info line on 131394. We hope the information in this video has been useful for you. As we said at the start, employment law can be complex and difficult to understand. Hopefully, after watching this video, it makes more sense and you are able to identify what issues you might have and who you can contact if you need further advice. To recap on that, usually if you are a national system employee, the Fair Work info line is the best place to call first, and the number is 131394. If you're a state system employee, Wage Line is the best place to call first, and the number is 1300 655 266. You can also use the info guide on our website to identify the fact sheets and information kits which are most likely to apply to your situation, or browse our information resources at your own pace. Finally, if you need legal advice about your specific employment law issue, you may wish to contact a lawyer, or you can call our telephone advice line to see if you're eligible for our legal advice services. Our advice line is open from 9 a.m. to 3:30 p.m. on weekdays except Wednesday. It is also open late from 5 p.m. to 7:30 p.m. on Tuesdays. The telephone number is 1300 130 956, or you can also call 9227 0111. If you're an employee in a regional, rural or remote location, our dedicated line is open from 9 a.m. to 1 p.m. on weekdays except Wednesday. The telephone number is 1300 520 054, or you can also call 9227 0185. We hope the information in this video has been useful for you. Thank you for watching and your interest in the Employment Law Centre.